We are here today, thank you. We are here today in the public deliberation in the matter of Hopewell Pointe. It's CBA number 19-017. And just by way of background, there was a director's letter of November 20, 2018, indicating that a proposed alteration of the development plan was a minor refinement as opposed to a material alteration of the Hopewell Pointe development plan. And that was issued pursuant to Baltimore County Code section 32-4-106 sub B sub 2. And the significance of being deemed a minor refinement is that things like procedural matters like community input meetings and a lot of adversarial components that would otherwise attend a development alteration are not required. We held a hearing on this, and by an opinion dated August 29, 2019, we issued an opinion 2-1 that the proposal was indeed a minor refinement and therefore fit within the parameters of 32-4-106 B2. This was then appealed to the circuit court, and by an opinion dated 8/10/21, that is August 10th, 2021, the circuit court reversed our decision and held that we too narrowly defined what constituted a material alteration. In other words, we said a material amendment. What we said in the majority opinion was that if density and the number of buildable lots was reduced, then that was the end of the story. That made it a minor refinement instead of a material amendment. And the circuit court held that there are other things that could constitute a material amendment, not just number of buildable lots and density. So it was remanded to the Board of Appeals for us to determine whether, under this broader standard, the Hopewell Pointe proposal was a material amendment or, again, a minor refinement. Now, I must confess that I'm the only one of the three of us who was here 18 months ago for the original hearing. And my recollection of I can read the memos, I did read the memos, but the nuance, frankly, is a little dusty in my recollection, in my brain. And the two of you are new to this whole matter. So what I would propose is that we schedule a 1-hour hearing to permit counsel for the parties to argue their positions again. I'm not suggesting that they redo memos, but I would find it useful from my point of view to hear the lawyers outline their positions in detail, and with regard to the specific facts of the Hopewell Pointe development. And so that would be my proposal. And I guess I'd want to hear what the two of you have to say about that. I think that's not typically how we do these things, but I would like to personally, I would like to do that so that we don't overlook an aspect of this that we shouldn't overlook. So, any comments?
I think I would agree with you, Mr. Chairman. Based on the direction from the circuit court, I can only assume that back when the original hearing took place, that council probably just assumed that the density and the buildable lots were the end all be all. So I think it's only fair to give council an opportunity to argue in front of us what to expand beyond those two factors from the county code 32-4-262.
Right.
So I would agree with you.
I think on a pragmatic note too, for both Mr. Pennington and myself, though we can glean from the record and go back and watch videos and things, it would be probably more effective for us as new panel members to hear the oral argument of counsel as to these matters before formulating our decision based on the guidance from the circuit court in light of their interpretation of the statute. So I am good with that. So I guess we can defer to our administrators to reach out to council to find some date where we can fit in just an hour on the Zoom and get this done expeditiously.
Right. And I don't think they need to rebrief it. I would hate to have the clients have to pay for that.
Yeah. No, I think argument should suffice, and I guess we'll talk to the administrators about reaching out to folks and trying to get that scheduled as soon as possible, especially since one of the benefits of having the Zoom is that we can fit it in somewhere for an hour quickly and,
Right.
and get it done.
Right. Okay. Well, anyone have any further comments?
I don't. Just as a housekeeping matter, I don't believe we need to reconvene in a breakout session as to the 9 o'clock deliberation. I'll speak with Tammy about how we're going to go about generating our correspondence as we discussed. Okay. And as for this one, it's a scheduling issue. So right. I don't think we need to convene.
Right. Okay. We're all good then. We will adjourn.
Thank you, John.
All right, great.
Thank you.
Thanks, Tammy.
Take care. Bye-bye.